Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, and so on. Now, this again is a very popularly used exemption, extremely popular. If you ask for names, they say it's personal information, so we will not give it to you. Name is personal. One cannot deny that, can you? And yet, the moment you meet someone, you give your name. Is it an issue of privacy at all? Is something that to be considered. That comes, everything starts going into burqas and cloaks. The way I interpret this is, first, to even claim exemption under section 81J, it should be personal. And personal, I say, must be, we must use words, we must interpret words in a law the way you would in a normal language. You do not say personal for an institution. A lot of people have said information relating to an organization, a commercial organization or a bank or anything is personal. I refuse to believe this. You do not say there is personal information of a bank. You do not say there is personal information of an institution. Therefore, to my mind, corporates, institutions cannot even think of claiming exemption under section 81J. They can, however, claim under the commercial confidence, etc. Secondly, after it's personal information, the question is, was this information obtained in the course of public activity or not? Most information is obtained in the course of public activity. And then the last test is it an invasion on the... My belief is that most, and here is my logic to this, I believe government has no right to invade the privacy of an individual. Therefore, information that is routinely taken from citizens, if we accept that it has no right to invade my privacy, that would not be an invasion on privacy as accepted by us. And therefore, the claim to privacy cannot be made. Then people have said, okay, what then qualifies under 81J? To my mind, information which normally I would not have given, but comes into the domain of, let's say a raid is carried out in my house and some information is obtained, then that is information which would fall under 81J. If my phone is tapped and like Amar Singh did, he was talking to his girlfriend, that is information that will come under the section of 81J. But most of the information I would, but on the other hand, my medical records would come under 81J. These are things which, what is privacy? I think we must begin to understand. What is it that we call privacy? What is it we call private? People have said, give me academic qualifications. People say 81J. Your academic qualifications are something that you routinely give about. So we must treat this whole issue of privacy, keeping in context the Indian context also. And I have another submission. I believe there are a lot of human rights which are universal across the world. Privacy, to my mind, is a social cum cultural concept. What is privacy in the United States may not be privacy in India and so on. And different countries will have different concepts of what constitutes privacy. And today, privacy has not been codified in the Indian laws. And to my mind, therefore, the right to information comes higher than the right to privacy within India. It does not mean everything that you do in your house needs to go out, but a lot of things for which privacy is claimed, and it's also a belief of what kind of position a society should take which will cause greater good for the society. My strong belief is, given our nature of corruption, given our arbitrariness, given our misgovernance today, and maybe for the next 2 decades, a greater amount of transparency is likely to benefit India and the nation far more than lesser disclosure of information. Section 81J has a proviso which says, provided that the information which cannot be denied to the parliament or a state legislature shall not be denied to any person. What can be denied to parliament? Really, there is no codification of this. Oh, why was this put there? The reason that we put it there, I was part of many hundreds of us who were helping in drafting the act at that time. The reason we put it there was, we said, we understand that most government servants will not get used to the concept of giving information to citizens. And who the hell is this citizen? Ye hai kaun? In Hindi, incidentally, we use the word Lok Shahi for a democracy. Lokशाही means लोगों की शहनशाही. You must feel like a Badshah or Begum. Unfortunately, this is not true. And therefore, we put this clause saying, but we were aware that government servants and government offices were used to giving information to parliament and legislature. When a parliamentary question comes, everybody works overnight and ensures that the information is provided. 10 officers will get together and say, information de do, MP ne sawal pucha hai. To show this concept that the legitimacy of parliament is derived from the individual citizen, this clause was put, and to put people in the frame of mind where I said, okay, ask yourself, will I give this information to parliament? If I will ensure that I will give it to citizens. That was the reason for this proviso there. And of course, section 8.2 says, notwithstanding anything in the Official Secrets Act, nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interests in disclosure outweigh the harm to the protected interest. So if you can establish a, mind you, you don't have to show public interest in the normal course. Only if somebody says this is exempted and the exemption is accepted, then there is a need to show larger public interest. Therefore, despite the exemptions, information can be given. Otherwise, you don't need public interest to be shown at all. Section 11, this is another commonly misused. Most people take it as an exemption. Information is third party, therefore I will not give it. That's not what section 11.1 says. Let's read this. Where a public information officer, as the case may be, intends to disclose any information or record or part thereof on a request made under this act which relates to or has been supplied by a third party and has been treated as confidential by that third party. There must be some evidence that it was probably treated as confidential and given by a third party. The public information officer shall, within 5 days from the receipt of the request, give a written notice to such third party of the request and of the fact that the public information officer intends to disclose the information or record or part thereof, and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. And it does not say if he says no, don't give it. It says, and such submission of the third party shall be kept in view while taking a decision. Kept in view in which manner? Kept in view cannot be arbitrary. Obviously implied is kept in view with respect to the provisions of section 8.1. Then why this need? The idea was that the assumption has been that the public information officer is likely to think of safeguarding the interests of the organization. Therefore, he or she will apply the exemptions and say this is exempted under section 8.1J, 8.1B, 8.1 whatever. But the PIO may not be very conscious of the interests of the third party. Therefore, the third party is given an opportunity to represent. But this representation should be with respect to exemptions in section 8.1. And the PIO will have to deny information only based on section 8.1. If you read the balance part of section 11.1, there is a provision whereby the third party can also go in appeals. Therefore, what has been envisaged is that the PIO may not accept the third party's view if it doesn't fall under the exemption, but the third party also can go into appeals. The whole provision of appeals would not have been there if the third party was given a veto right. But this is very, very, very often, I would say, number of cases I have come across where PIOs just say, this third party, in fact, they don't even ask, they just say third party information and nahi dega. Yeah, they say third party ko pucha, third party ne mana kar diya. That's not the way the law really is structured at all. 11.1 is not an exemption. It's only a procedural. Okay, now some necessary actions by public authority. Clearly identify the holders, the deemed PIOs of various records. This is missing. Maybe the banks are better placed, but in lots of other public authorities like municipal corporations and governments, this is completely absent. PIO should directly send his requisition for information to the holder of the record. This is another problem with most government departments. To describe a standard MCD, which is one of my nightmares, the Delhi Municipal Corporation. The PIO will mark it to A, B, C, at least it will go through 5 or 6 signatures. All of who will say, sir, I don't know anything about this. I ask them, why do you sign? Sir, process hai, procedure hai. Iske liye sign karta hai. Then I tell them, why don't you just put your thumbprints? Because if you, honestly, PIO will say, sir, I know nothing about it. I just initialed and sent it. And it will go through 4 or 5 such steps. and then somebody somewhere will give information and so on. Ideally, even if that is the case, my submission is give it directly to the holder of the information. That will speed up the process. Others are unnecessarily wasting time. All holders of record must understand the relevance of 5.4 and 5.5 in the liabilities. Holder of record can either be the person actually holding the record or the administrative head of the unit. If the public authority decides that the administrative unit must be referred to, such administrative head must be held responsible for providing the information and be liable as a deemed PIO for purposes of section 21 of the RTI Act, which is the penalty clauses. Time plan, which I talked of earlier, is what I am repeating. We'll skip this. If prima facie information must be provided, the PIO should find out what are the charges leviable, inform the appellant, and of course, the last part, if some of the information has to be obtained from another officer, send him a note and seek his assistance under section 5.4, stating that he must give you an answer within 15 days. Voluminous information, section 7.9 of the RTI Act covers this. Yes, I have seen this and I do not justify it. People asking 50 queries, 100 queries, 20 queries. In fact, about 6-8 months back, DOPT had put a proposal saying that they will modify the RTI rules. And one of the things they had proposed was that the limit in number of words would be 250 words. I personally am a person who believes that was a good rule to put across. Unfortunately, the government could not put it through. I mean, there was a lot of opposition from civil society on the rules as such. But I do believe that a rule which says some limit on the RTI application in terms of words. I've seen RTI applications running into 25 pages. I mean, more than 100 I've seen them. And when they come for a hearing, I tell them, look, you tell me your key 3, 4 things, 5 things, or I'll give you an inspection. And they say, no, you must read the whole thing. And I've told them, I'm sorry, I'm not willing to read your whole application, because if I do that, I'll need hours and hours. And whereas you have a right, I think as a commissioner, the rights of those who are in the queue also must be consciously remembered. So I do believe time-bound disposal by all commissioners is necessary. Therefore, one citizen cannot take up a completely inordinate amount of time. So 7.9 is what people can use and offer also inspection of records. My submission to a lot of people is, when you get something that will be very voluminous, don't even wait for 20 days. Immediately send a letter saying that under 7.9 cannot refuse. You can say, okay, I'm willing to give you 5,000 pages of photocopies at 10,000 rupees, or you are welcome to come and inspect. So you offer an alternate method of offering the information. 7.9, you cannot say it's voluminous and therefore I will not give you information. The first appellate authorities, it's a statutory duty is what the point I would like to bring across to all first appellate authorities. It's a very important role. As soon as an appeal is received, it must be listed for hearing, preferably within 10 days. A reasoned speaking order must be issued. And a good appellate mechanism will save officers from penalties. If an appellate mechanism works properly, then your PIOs are unlikely to face penalties, because penalties can only be imposed by the commission. And even if in the rare case a penalty is imposed subsequently, the number of days of imposition of the penalty will be much less. Typically what happens is, by the time the thing comes to a commissioner hears it, in most cases the penalty becomes 20,000-25,000 rupees. Whereas if the first appellate authority has arrested it there, even if a penalty was levied, very rarely a penalty is levied if the information is completely provided by the time the first appellate mechanism works. It's a critical role. It's a duty which must be fulfilled. Hearings are a must unless the appellate authority is convinced that the information must be provided. I would say that if a first appellate authority sees information has been, he can do this without a hearing. He can just say, I believe the information needs to be provided, and why even call for a hearing? The information can be provided directly. Reasoned orders must be given keeping in mind the RTI Act. Keep the RTI Act in mind and certainly give your reasons. When asking for information to be provided, identify it clearly. This is a common problem. Quite often the first appellate authority says some information has not been provided. Nothing is identified. And then the PIO comes and says, this is not what I understood. So it is worthwhile for first appellate authorities to clearly say, this is the information that when some information has been given before, that I believe this is the information which was not given and this is the information that must be provided. And well, I have done this because quite often in various bodies, first appellate authority is not discharged the duty. And they kind of say, information commissioner kya karega humko? When answering multiple questions, a tabular format is useful, is a suggestion that I am making. Some tips for applicants. Think of your objective and then ask for information. Quite often citizens are asking for information with no reference to what is their objective. No, they have standard sets, so, अरे पूछ रहा है तो और भी पूछ लो ना, ये भी पूछ लो. I've asked citizens, what are you going to do with this information? And they have no clue. I remember somebody coming to me and saying a series of questions which said, I want a copy of the tender, I want a copy of the specifications, I want the quantities estimate, I want the bills and so on and so forth. And I said, what is your objective? One of his things was, I want samples of the core taken from the road. I said, what's your objective? He said, sir, rasta bahut kharab hai. I'm convinced the concrete use has been bad. I said, okay, let's agree. Then what is it you want? मुझे वो core चाहिए. तो अगर core चाहिए तो बाकी से आप क्या करोगे? What will you do with all these estimates? Can you even understand them? Can you make any analysis of them? And the answer was no. So if you can do nothing with it, why are you asking for all this? And therefore, in fact, I must put it the other way around. Even if you come to a commission, let's say this is a common thing. A person will ask 20 questions. A PIO will have reasonably replied to it, to 19 of them, let's say, and one he didn't probably appropriately reply, and the fellow says, sir, मुझे actually यही चाहिए था. The question is, why do you ask the other 19? The aim and purpose of right to, people often say, मैंने इसके सामने RTI किया. I did an RTI against so and so. I may have used the same language 5 years back. Not just before I became even before I became a commissioner, some of these realizations came. No, you don't. RTI is not against anybody. RTI is to get information as it exists on records. You are only getting the truth as it exists on records. We need to get this out of our mind that it's against somebody. It is never. It's never against anybody. As Debashish said, I used to call this a Brahmastra initially when I saw the power of it. But I recognized that it was a flawed way of looking at it. I cannot use a weapon against my government. I want my government to improve. I want my nation to improve. And my nation cannot improve until my government improves. I cannot get a first-rate nation with a third-rate government. And that's the purpose of right to information. It may be to solve your own personal grievances, fair enough. But do not look at it as a weapon to taunt somebody, to hurt somebody. Look at it as saying, I'm going to get the information that exists on records. And when you ask a focused RTI query, I had filed some 800-900 RTI queries myself in about 4 years. But almost all my RTI queries were probably less than 150 words. The actual seeking of information, 99% of them were within 150 words. And you can do that. And when you do that in a focused manner, the PI also finds it difficult not to give you that information. So think of your objective, frame your query, certainly ask for information. Focused application of the minimum queries will usually get maximum results. Be brief. Ask yourself, how brief can I be? Avoid taunts or aggressiveness in application. Because when you use taunts or use aggressiveness, it puts off the other person. The other person is also a human being like you. If I talk to you, your immediate response is to respond in that manner. It's a human response. It's not a matter of whether I'm a government officer or not a government officer. All of us will respond to human beings. And remember, when I at least put across the concept saying you are a sovereign citizen, the PIO is also a sovereign citizen of this country. So let's respect each other as individuals. Nobody is below you. We are all equals. Information must exist. PIO are not expected to give his opinion or clarification. RTI is a tool, not a weapon. Do not approach PIO personally. Quite often people say, मैं 4 बार जाके मिला उसको. Please don't do that. Follow the process, file your RTI application. I would normally recommend send it by speed post. That's the most effective, cost-effective method. Send it by speed post, non-personal it remains. You don't go and meet somebody, you go to some place and say, वो counter पे वो नहीं था, that fellow told me this, I told him this, he refused to take. Send it by speed post. That's your most, and Almost all my RTI applications used to be spent like that when I was sending these RTI applications. When answering multiple questions, a tabular format is useful. Some tips for, oh sorry, I went back. Some bottlenecks. Lack of culture of transparency. We really lack this culture of transparency, and as I mentioned earlier, I've actually found that our courts, which talked loftily about the fundamental rights of citizens, have, the moment RTI came, have been very, very slack and niggardly in giving information themselves. We actually have a case right now where the Supreme Court has gone against the judgment of the Delhi High Court, first given by a single judge, then by a division bench, to the Supreme Court. The Supreme Court is the petitioner before the Supreme Court itself in an RTI matter, which is really a sad reflection of the state of affairs. Lack of awareness of the law among citizens and PIOs. This is also true. Citizens also do not know this law very well, nor do PIOs, but I think if you go approach it with the right spirit, I'm sure we'll get over this, and the awareness of this law is growing. I think there is no other law in this country that the level of awareness is so high, though it's about 6 years now. Another major bottleneck is the Information Commission's slow pace of disposals. It's very unfortunate. Information commissions are service providers like anybody else. Just as if you apply for a ration card, you expect your ration card should be delivered in X time. You apply for a passport, you expect that it should happen. I genuinely believe all judicial and quasi-judicial functions must deliver to citizens within some reasonable limited time, which they must commit. Unfortunately, this is not true, and this is, mind you, not just of information commissions. We've got scores of commissions across the country. Scores. My own guess is there will be about 3,000 to 4,000 such different kinds of commissioners at state level and central level. Most of whom cost the country, nation individually between 20 to 25 lakh rupees a year. That's my cost to the nation, incidentally. But what they deliver is extremely pathetic. Most of them think they don't need to be accountable at all, and citizens are part of this. None of us has ever sought. Have you ever asked the judiciary, how many cases do you dispose? And why don't you dispose so many cases? We don't. We've got used to this. And therefore, judicial and quasi-judicial bodies feel they can take all the time in the world. I believe there is a need for accountability, and there is a need that they must make a commitment and a promise to citizens that we will deliver within a reasonable time. Without timeliness, these organizations may as well not exist. And since information commissions are going slow, very slow, there are commissioners that are disposing at the rate of 200, 300 appeals and complaints in a year. I had gone to Odisha 10-15 days back, and the truth is the backlog now is about, if they look at the current rate of disposal, it will take another 7 years for them to dispose that. At which point RTI is dead. And slowly, because citizens have got used to this, quasi-judicial and judicial bodies, we say, wo to jo harta hai, karta hai. Slowly, this will choke RTI. I would submit there should be a demand at the Central Information Commission. Fortunately, 4 months back, we have at least set a norm and said all commissioners will dispose at least 3,200 cases in a year. And I believe this needs to keep increasing. And this need for accountability, this demand for accountability must come from you, the citizens. Unless you make this demand on the judicial and quasi-judicial processes, justice as we call it, to my mind, the judiciary doesn't exist for the what we call the Aam Aadmi of this country. The Aam Aadmi of this country, the judicial system doesn't exist at all. 60% people in jails are there because without conviction, their only fault is that they are poor. That's the only fault they have. Unwillingness to accept mistakes is another problem. Most of us are scared to tell the truth because we believe somebody will laugh at us. I believe let's accept this. And as our mistakes get exposed, we have a better chance of becoming better individually and as an act to provide information. Public interest is paramount. Leads to true participatory democracy, the Swaraj that we all hope to get. Transparency brings truth and sunlight are healthy, as Mr. Das said. And let me give you one simple case of a public authority in Delhi, which represents what can really happen. It's a very small example. Delhi Subordinate Services Board in Delhi selects people for various subordinate services in the Delhi government. Someone had asked a query. He had applied for a job. Obviously, he has not been selected. And he said, if two candidates have the same marks, how do you decide whom to select? Apparently, the rule there is that the person who's senior in age is selected, and by some mistake, the junior person had been selected and this man had been left out. What I found very elevating was that the PIO within 15 days had replied that the person senior in age should be selected, and we admit that we've made a mistake in your case. He couldn't rectify it immediately, but he admitted the mistake right there. This person, of course, came in appeal because what he was looking for was to get the job. I mean, that information, he was not really looking for information. So I explained to him, I said, look, I cannot really help you. Then the PIO said that they are trying to see how, if they can, absorb this man because injustice has been done to him. But I was absolutely thrilled and amazed that this body, they had made a mistake, they had put it on paper. They had not tried to resile or block information. They said, fine, we made a mistake. And mistakes will be made. We are all human. As human beings, as institutions, we all make mistakes. I don't think there's anything, I'm not saying we should keep making mistakes every day. But I think recognizing a mistake, accepting a mistake is something that we should get used to. With this, I would then ask whatever queries you have, questions you have. But my simple plea to all of you is, believe me, we are at the cusp of a beautiful position today. And citizens are also slowly becoming empowered in various ways. I'm not saying right to information is the only thing. Right to information has been one of the tools that has empowered citizens. We are seeing this change. If we have to sustain it, in the next 10 years, we have an opportunity of changing the face of democracy in India. We have a chance of changing the way democracy works, empowering citizens, getting into participatory democracy, which is really what I think a good nation and a good government, and we need to, a small thing, I believe our governance is pathetic today. We need to change that, and only when all of us get together and press for it will we get that change. Thank you very much, ladies and gentlemen. Thank you.